Good afternoon and welcome back to the Public Service Commission as we continue in the hearing in dockets 2023-388-E and 2023-403E. All commissioners participating in this proceeding are present in the hearing room. Ladies and gentlemen, we will go no later than 4 p.m. today, just for your edification. I think we are very hopeful, and this is the plan, is that we will, I don't see us finishing today. So with that, we are going to, we will recess until 2 p.m. on Wednesday. We will go for a while on Wednesday afternoon. We will come back and start at 9 a.m. on Thursday. We do have to conclude around 3 or 3:30 because the commission has a public night hearing in Aiken and another docket. And then that will leave us on Friday as well. But hopefully that will allow the parties this afternoon, Wednesday afternoon, Thursday for 2/3 of the day, and Friday will allow the parties sufficient time to present their cases as they see fit. And if not, we will figure out where to go from there. So just to give you an idea, that's the plan, provided nothing goes haywire. So thank you very much for your patience and your endurance as we have gone this week. And so, now, Mr. Hall or Mr. Edwards, I think we're to you. Is that correct?
That's right, Madam Chair. And just a little bit out of order from the sheet that was presented, we are going to call Mr. Eric Borden first.
Mr. Borden first? Good. Good afternoon, Mr. Borden. Can you hear me? Mr. Borden, can you hear me?
Yeah, I'm sorry. I'm getting an echo, so hang on one second.
Is that because you're using earbuds and have your computer on, maybe? Does that help any with the echo?
Okay, let's try now. Can you hear me?
We can hear you. Can you hear me?
All right, I'm only hearing one of you now, which is easier.
Okay. I don't think anybody wants to hear two of me. I can tell you that. Mr. Borden, this is Chair Belser talking with you, and I'm going to ask that you raise your right hand and let me swear you in. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Mr. Hall?
Good afternoon, Mr. Borden. How are you?
Good, how are you?
Good. Can you hear me okay?
Yes.
Great. Okay, can you please state your full name and business address for the record?
Yes, give me one moment, please. My name is Eric Borden. Business address is 485 Massachusetts Avenue, Suite 3, Cambridge, Massachusetts.
Thank you. And by whom are you employed and in what capacity?
I work for Synapse Energy Economics as a principal associate.
Okay. And did you prepare 43 pages of direct testimony for this docket, which is filed on April 8th, 2024?
Yes.
And did your direct testimony include 5 pages of exhibits labeled EB1?
Yes.
Do you have any corrections to your direct testimony?
I do, and I apologize for this. In my direct testimony, page 23, lines 1 through 5 should be deleted. Those sentences are incorrect, but they do not affect my analysis or recommendations.
Okay. Thank you. Madam Chair, we have not had a chance to file that corrected testimony, but for the sake of this, I was going to ask, hopefully we'll be able to do that this afternoon. But I would move to have the corrected pre-filed direct testimony of Mr. Borden entered into the record as though given orally from the stand.
Mr. Borden's pre-filed direct testimony as amended from the stand will be admitted into the record as if given orally.
Thank you. And Madam Chair, I'd also move to have Exhibit EB1 entered as the next applicable hearing exhibit.
I'm sorry, I was checking my notes. Mr. Borden's Exhibit EB1, which was submitted with his pre-filed testimony, will be marked for identification as hearing Exhibit 35 and admitted into the evidence of this case.
Mr. Borden, did you also prepare 12 pages of surrebuttal testimony, which was filed in this docket on April 29th, 2024?
Yes,
And do you have any corrections to your surrebuttal testimony?
I do not.
If I asked you, given the corrections that we noted earlier, if I asked you the same questions today, would your answers be the same?
Yes,
Madam Chair, I move to have the pre-filed surrebuttal testimony of Mr. Borden entered into the record as though given orally from the stand.
Mr. Borden's pre-filed surrebuttal testimony will be admitted into the record as if given from the stand.
Mr. Borden, have you reviewed the settlement agreement filed in this matter?
I have done an initial review, yes.
And do you have any concerns with it?
I do. Broadly speaking, several settlement terms do not sufficiently address the findings in my testimony or are not adequately supported in their own right. I'll provide a few instances. First, regarding coal ash remediation costs, if the Commission is going to allow a debt return on deferrals, and to be clear, I do not support any return for these expenditures, it should examine why the settlement allows for the company to get return at the current debt rate rather than the previous debt rate. The company is not borrowing money now, it is borrowing money when expenditures occurred, broadly from 2019 to 2023. Second, the settlement presented approved all but just $2.5 million of targeted undergrounding costs, but the company has not demonstrated reasonableness for $42 million of those costs.
And Chair Bell, sir, I would object. These are new recommendations. This is not a summation of his direct testimony or his surrebuttal testimony.
Madam Chair, as we had talked about previously on Monday, given this settlement testimony, I thought it'd be proper for our witness to be able to respond to it just briefly.
I'm going to allow some latitude here because the settlement did come in late, and I'm not criticizing that, but just because of the schedule that we have been on, I will allow this. Of course, the council will be able to examine the witness on his statements.
Thank you, Chair.
Thank you.
Mr. Borden, did that conclude your assessment of the settlement agreement?
Yes.
Okay. And have you prepared a summary of your direct and surrebuttal testimonies?
I have, and I'll go over that now.
Thank you.
Good afternoon, Commissioners. My testimony addresses 4 primary issues: cost recovery options for coal ash remediation costs, deferrals for O&M expenses, self-optimizing grid or SOG costs, and targeted undergrounding or TUG project costs. My testimony covers several topics.
Just a moment, Mr. Borden.
I don't believe that we've received a copy of that summation.
We have not had a chance to prepare one. I wasn't under the impression that was required. I know for the convenience of the court reporter, we do typically provide them, and we'll try to get that later for her convenience as well.
We don't have one either.
Okay.
It's fine. It's not that anybody's being left out. So, thank you.
Thank you.
Mr. Board, would you mind restarting? I'm sorry.
Sure. So, good afternoon, Commissioners. My testimony addresses 4 primary issues: cost recovery options for coal ash remediation costs, deferrals for O&M expenses, self-optimizing grid or SOG costs, and targeted undergrounding or TUG project costs. My testimony covers several topics within these areas, some of which I will summarize now. Regarding coal ash, the company's poor record of environmental violations pertaining to basins where it seeks cost recovery of remediation costs means that full or partial disallowances should be considered. At minimum, it would seem to add insult to injury to allow returns for costs related to activities intimately connected to illegal behavior by the company. I find that coal ash remediation should be treated as O&M expenditures, not capital expenditures, which can affect the historical and future cost recovery accounting treatment for these costs, if any. The Commission should consider affordability in its decision on how to treat coal ash deferrals in the past and any in the future. The manner proposed by the company for cost recovery of these expenses is the costliest way to recover coal ash remediation costs from ratepayers. For the TUG program, critically, the company did not consider alternatives to undergrounding, the most expensive mitigation available in its cost-benefit analyses. Furthermore, I found that the company's use of generic average unit costs and cost-benefit analyses is inappropriate for TUG and resulted in several projects where cost-benefit analyses significantly underestimated unit costs and therefore overestimated the benefit to cost ratio of projects. For the SOG program, the company's cost-benefit analysis demonstrates that just 2% of the reliability benefits on an economic basis will accrue to residential customers, yet residential customers will shoulder around 60% of costs. This means the investment is not in the interest of residential ratepayers under the traditional cost allocator used. My recommendations include, but are not limited to, the following. 1, the Commission should consider partial or full disallowances of coal ash remediation costs. 2, the Commission should deny past deferred and future returns on coal ash remediation costs. 3, the Commission should deny cost recovery of $42 million for TUG expenditures. 4, the Commission should allocate costs for the SOG program generally in proportion to benefits of the program. 5% to the residential class, 95% to the commercial and industrial classes. And 5, Duke should evaluate the costs and benefits of its programs when it seeks cost recovery rather than rely on prior analyses that may differ from actual implementation.
Thank you, Mr. Borden. Does that complete your summary?
Yes, it does.
Madam Chair, Mr. Borden is available for questioning from other parties in the Commission.
Thank you, Mr. Hall. Duke Energy Carolinas.
Good afternoon, Mr. Borden. My name is Melissa New, and I'm here on behalf of Duke Energy Carolinas. How are you today?
Good, how are you?
Good, thank you. Now, in your testimony, you also provide recommendations regarding the company's grid improvement plan investments, and you just provided a preview of those, correct?
Yes.
Okay. Now, you weren't involved in DEC's last rate case in docket number 2018-319E when the grid improvement plan and its programs, including targeted undergrounding and the self-optimized grid program, were first introduced, were you?
No.
And were you aware that as part of a stipulation in that rate case with the ORS, that Duke Energy Progress and Duke Energy Carolinas agreed to a separate proceeding to advance further stakeholder discussions and commission review?
I was aware that there's a separate proceeding to look at those things.
Okay, so you did review the company's petition and exhibits regarding the grid improvement plan that were filed in docket number 2023-403E, which has been consolidated with this proceeding?
I've primarily reviewed exhibits in this docket, and I think there's some overlap between them. If not, then I likely have not reviewed those.
Okay, but you did review company and witness guidance, direct testimony, and exhibits?
Correct.
Okay, so you're aware that since the last rate case, the company and Duke Energy Progress have also been filing annual status updates on the grid improvement plan in an informational docket.
I was generally aware of that, yes.
And you're also aware that, as discussed on page 28 and lines 14 through 17 of Mr. Guyton's direct testimony, that the company has hosted several virtual forums since 2018 to report on the progress made on the grid improvement plan.
I don't recall that at the moment, but that may be true.
Okay, well, I can show you Mr. Guyton's testimony on
Well,
that
I
point.
can,
Do you have that in front of you?
I believe you.
All right, and then they'd also provide program and project highlights, as well as take questions and receive feedback from the participants.
Yes, I don't know the full context. I don't believe cost recovery was part of that, but I understand that there were some informational filings before this rate case.
Okay, and so you didn't attend any of those 7 virtual forums that were held between December 2nd, 2020 and October 12th, 2023, when the company discussed targeted undergrounding and the self-optimizing grid programs, did you?
I did not personally. I don't know if folks from the department did or not.
Okay, so you didn't provide any feedback on the company's targeted undergrounding and self-optimizing.
Madam Chair, object to the relevance of whether Mr. Borden provided feedback during meetings from 2020 to 2022.
Ms. New?
So we're just establishing that that he does not have any basis on the background on these programs of which he's testifying about. The DCA also could have participated in those and provided some of the feedback.
Overrule the objection.
Now I see at the bottom of page 3 of your direct testimony, in Exhibit EB-1, that you provided testimony in the Duke Energy Progress LLC rate case in docket number 2022-254E, correct?
Yes.
And you and the Department of Consumer Affairs didn't provide any testimony opposing Duke Energy Progress's same targeted undergrounding program in that case, did you?
Madam Chair, I object to the relevance of what the department or Mr. Borden did in Duke Energy Progress's case.
I will sustain that objection.
All right, now I'd like to talk to you about your recommendation regarding the company's targeted undergrounding program and its grid improvement plan. You're recommending a full disallowance of the company's investment in its program, correct?
Just for the TUG program, that's correct.
Yes, thank you for this targeted undergrounding program. I should have clarified. Now, there are a number of reasons a utility may underground its distribution lines, correct?
Correct.
All right. One of those reasons might be for beautification aesthetics. Customers might request that.
I understand many utilities have programs where there's normally cost sharing between communities and the utility to do that type of project. I don't think that was part of the reasoning here, or at least I haven't seen any of that. But yes, that utilities do have that, and I'm not aware of what that program is for DEC specifically.
Yeah, and I'm not suggesting that's part of Duke Energy Carolina's program. I just wanted to walk through maybe some of the reasons a utility may underground. Another one of those might be public interference accidents, like cars hitting poles. Would you agree with that?
It could be. I mean, hopefully utilities are examining several alternatives, including just moving the poles rather than undergrounding them. But there could be, I would guess, probably rare circumstances where that might be appropriate.
Okay, and then greater resilience in areas that are prone to severe weather, like hurricanes, maybe another example.
Correct.
All right, and then safety, where you have energized lines falling from trees outside the right-of-way of a utility may not have permission to trim. You don't want down live wires whenever possible, correct?
Certainly that could be a reason. You know, you'd have to go much further than that for undergrounding to say, here's why we undergrounded. You wouldn't want to say every time a wire falls down, you underground the line, and I don't believe DC is proposing that.
Yeah, fair enough. And then neighborhood rear lot construction in heavily vegetated areas that are difficult to access.
You'd want to look at a variety of factors for why to underground a particular line or line segment.
Okay, and then finally, wildfire risk mitigation, particularly in the western United States, right?
Correct.
Okay, now looking at your direct exhibit again, EB1, You provided testimony in a number of California proceedings involving Pacific Gas and Electric and Southern California Edison, correct?
Yes, and San Diego Gas and Electric.
Okay. And you're aware then that they've been addressing wildfire risk and mitigation in many of those proceedings in California, correct?
That's correct.
Okay. In fact, you've sponsored expert testimony on wildfire mitigation strategies and costs, correct?
Correct.
So you're aware that as part of its efforts to mitigate the risk of wildfires, PG&E is planning to underground over 10,000 miles of overhead lines.
That is what they are saying they are proposing. I am strongly opposed to that, if you want to even call it a plan. And I have made recommendations to the commission, some of which have been adopted, to significantly scale back their undergrounding proposal because it's not based sufficiently in risk mitigation or what California needs to safely operate its electricity system.
Thank you. And to be clear, DEC is just undergrounded only 25 miles in the last 5 years, correct?
Correct.
Now, part of your recommendation to allow all $42 million of targeted undergrounding cost is based on your assertion that there may have been other more cost-effective solutions the company could have chosen instead, correct?
Correct. I think you meant disallow. Yes, correct.
And in your testimony, you note a few alternatives the company could have considered, such as more vegetation management, equipment maintenance, or repair, or covered conductor or reconductoring, correct?
Correct.
Again, looking at your direct exhibit, EB-1, your educational background is in finance, entrepreneurship, and public affairs, correct?
Yes, correct.
Okay, so you don't have any experience employed by an electric utility in a distribution, transmission, or grid planning function, do you?
I have never worked for a utility, correct.
You've not worked in the field performing maintenance work on distribution lines, correct?
That's correct.
All right, you've never been in charge of defining and executing a distribution maintenance program, have you?
Correct.
And no in the field experience as a distribution engineer?
Madam Chair, I believe he's answered that he's never worked for a utility company. So he's competitive.
Go ahead, Ms. New. He did answer it. It's not, I think she's just laying some groundwork, but let's not repeat questions, please.
Absolutely. Thank you, Chair Bellster. I'll move on. You didn't physically visit any of the sites where DEC has implemented targeted undergrounding projects to assess the location and conditions of that area that might be contributing to the reliability issues that the company's trying to address, did you?
I reviewed the information that the company provided in its testimony and in discovery. I did not do anything beyond that.
And on your direct pre-filed testimony, you acknowledge that the potential alternatives that you suggest the company might have considered might not provide the same level of reliability benefits as targeted undergrounding, correct?
So I think you're referring to some examples I gave. It really depends on the location and the particular drivers of reliability and resilience events to determine mitigation effectiveness. But I do think it's fair that undergrounding tends to be tends to have the highest what I've referred to as mitigation effectiveness, meaning because the lines go underground, the drivers of overhead faults and downed wires will essentially be eliminated, not completely, because of course underground lines also fail.
Okay, and you're aware that when the company identifies its targeted undergrounding projects, it's looking for a permanent solution to the reliability problem on a portion of that circuit.
Yes, I understand that removing an overhead line um, and putting it underground will eliminate the outages from drivers of faults on the overhead system.
Okay, would you agree that vegetation management is not a permanent solution? And what I mean by that is you have to continuously go out and trim those trees. The vegetation continues to grow. It's not a one-time fix.
Correct. And there are situations where you can remove, say, an overhead or overhanging tree that could provide mitigation for that line based on that tree. But it's generally correct that trees grow and you need to go back and trim them again.
And are you aware that about half the vegetation-related outages the company experiences are the result of tree fall-ins from outside of the right-of-ways that the company can't touch without the customer's permission?
No, I haven't looked at specific data on drivers of overhead outages. My primary contention was that is what the DEC should have shown the commission that it did look at.
Okay. And you understand that reliability challenges the company is trying to address through targeted undergrounding are still occurring on these circuits, even though the company is already trimming trees on those circuits through its vegetation management program, correct?
Yes, and one way of, one can look at accelerated programs of vegetation management or other, ways of getting at just traditional vegetation management. Of course, as you mentioned, I didn't just talk about vegetation management as an alternative, but it is one.
Okay, and did you hear Mr. Guyton when he testified and talked about the company's integrated vegetation management program, and he also talked about reactive tree trimming program?
I think I heard most of that, yes.
Okay, so you understand that in addition to their standard cycle tree trim, they also have a reactive program that addresses other issues that vegetation may be causing on the lines, whether customers call that in or they self-identify it?
Yes.
Did you undertake any analysis of the company's current vegetation management practices related to the circuits for which targeted undergrounding was selected?
Again, that's what I'm saying the company should have done in presenting whether its costs are just and reasonable. And so I did not have sufficient data to kind of do this analysis for the company or to supplement their analysis.
Okay. Did you, now you mentioned 3 times in your direct testimony, you cite to the company's response to ORS 5-51. Do you recall that? It's on 3 times in the footnotes on page 27 of your direct.
Yes, I see that.
All right. Hopefully you can see this. I think council is maybe emailing this document to you as well.
Ms. New, is this confidential?
The entire document is, but this page itself is not.
Thank you.
Okay. And do you see on page?
I'm sorry, Ms. Did you say somebody was emailing it?
Yes,
to us?
we have emailing and we also have copies, hard copies.
Okay. Yeah, a copy would be great, or if there's an email coming, I haven't gotten it yet. I appreciate it, sir. My computer's having internet issues this week, unfortunately, so I can't access everything. What page are you on again?
Yeah, I'm on page 12
Thank
of the attachment.
Ms. New, I haven't received it yet, but it looks like there's more than one page here. Are there confidential pages within what's being handed out?
So the entire document is, yes, it's confidential. It's because it's resources that Duke Energy expended to create their procedure, but the individual passages that I'm going to share are not confidential.
Is this the entire document or just portions of it?
That is the entire
So
document.
this, I just caution everyone that this is confidential.
Don't want to interrupt you. I'm sorry. And I'm fairly certain that we were told at some point in time that this document was not confidential, but just if that helps anyone, I don't know if anyone from Duke can clarify.
So, Mr. Hall, Chair, we'll double check to confirm. I did, as I saw the packet being handed out. The interveners that the packet has been handed out to have all signed NDAs. Let us, as Ms. New said, I think we're focusing on just one page for now, and I'll do that verification as well to confirm whether the entire thing is confidential or not.
Well, I'm just cautioning in case anybody tries to ask questions from this document that I don't want confidential. I'm trying to avoid confidential information from being discussed in open session.
Understood.
If it's okay, I'll just go off the screen. Hopefully I can see it.
Okay, Mr. Borden, are you able to see the document?
Yes.
Okay, can you read that third bullet that I've starred there?
It says, are there other solutions that may better address the problem than undergrounding?
Okay, and so this is part of the company's procedures as to what it follows when it's looking to whether or not to proceed with target undergrounding of a project, correct?
That is what it appears to be, yes.
And then I'd also like to turn your attention to page 23 of this document. Again, this particular excerpt is not confidential. Can you read for me that middle bullet there halfway through the page that I've starred?
It says, using engineering judgment better resolved by another solution.
Okay, and that's talking about when they go out to do a field assessment, their engineers will look to see if there may be a better solution to the issue that they're trying to resolve there, correct?
Yes, that's what it appears to be. Yes.
Now, would you agree that it would be prudent to look at the feasibility of other alternatives before you expend customer funds to do a cost-benefit analysis on multiple options that might not solve the problem?
Sorry, could you say that again?
Absolutely. Would you agree that it would be a prudent expenditure of customer funds if you first looked at the feasibility of other alternatives before you spend that time and resources to assess those alternatives? In other words, if an alternative won't solve the problem, should we spend time doing financial assessment of that alternative?
So you're saying that if we should trust the utility's subjective assessment of a particular location and project, and then trust that, well, the utility decided, let's not look at alternatives at all. What I'm saying is that in order for the utility to show that its costs are just and reasonable, it needs to show that type of analysis.
Okay, but you also have testified that you don't have any experience in the field doing this kind of work on lines to be able to make that analysis yourself, correct? You didn't do that analysis either?
So so what I did was review the company's filing and its discovery responses on this issue. I think if the company has information that it could have shown that said, look, here's what additional vegetation management would have cost, here's what covered conductor could have cost, here are the specific drivers on those lines that's causing the issue, and here's why undergrounding was really the only way to do it relative to other places where, everywhere faces some risk. Is the utility choosing truly the best places? It has just not presented that information.
Okay. We may agree to disagree on that one, but you submitted pre-filed testimony on February 29th, 2024 on behalf of the Utility Reform Network in Southern California Edison's 2025 general rate case, addressing its wildfire grid hardening investments in that case, correct?
That sounds right. I don't have the date in front of me.
Okay, and I may have missed it, but I did not see that one listed on your Exhibit EB-1. It's docket A2305010.
Yeah, I think the resume I submitted only goes through like last year, 2023. So there's probably a fair amount of testimony that's not quite updated yet, and I'll get there eventually.
Fair enough. And so you're familiar then that SCE is proposing about $4.2 billion in spend from 2025 through 2028, primarily for undergrounding overhead power lines, correct?
That's right.
Okay, and in that case, on behalf of TURN, can you read your recommendation here? And I'm, again, going to place this on the Elmo, and we do have copies of this and are able to email this. And just let me know when you're able to see it, and the council is.
Could we have just a second, please? And I'm sorry, once again, what page are you on?
Yeah, I'm on page 2. And I'm looking at lines 1 through 7 of his testimony.
Thank you.
Thank you.
Can you say which lines you wanted me to read?
Yes, if you could read to us your recommendation in lines 1 through 7.
Sure, it's a little fuzzy, but oh, thank you.
Sorry about that.
Yeah, that's better. Ooh, yeah. Okay. Based on our analysis and findings, TURN recommends a truly targeted undergrounding program that focuses on the very highest risk miles. Specifically, SC should be allowed to deploy up to 44 overhead miles per year of undergrounding over the rate case period, subject to a location-specific analysis of alternatives that shows undergrounding is the most cost-effective solution, or if not, that undergrounding can be justified as a preferred alternative based on factors showing that overhead hardening would have limited effectiveness at the location in question.
Thank you. And then based on your testimony that you view targeted undergrounding as too expensive, and there could be alternatives that you admitted you haven't analyzed, you came to the recommendation that every single dollar the company spent on its targeted undergrounding program in the past 5 years should be disallowed, correct?
Correct, and again, my position is that the company needed to show that analysis to present why those costs are just and reasonable. As you just saw in the Edison case, what I was able to do is say, no, this full scope of undergrounding is not just and reasonable but here's a much more reasonable scope. California is in a forecast rate making. Here we're doing historic. And so since that data was not available here, that type of analysis was not possible.
Yeah, thank you. Now I want to talk to you about your recommendation for the self-optimizing grid allocation specifically, and you're recommending that the company allocate the cost according to the economic benefits assigned in the company's CBA, correct?
Generally speaking, that's correct.
Okay. And you're proposing an allocation of 95% of the cost to commercial and industrial customers and just 5% of the cost to residential customers, correct?
Correct.
And you can reasonably quantify how much an outage may cost a manufacturing company and lost revenues, correct?
There are methodologies to quantify that, and that's what the company has relied on in its cost-benefit analyses.
Okay. And would you agree it's more difficult to assess the cost of an outage to residential customers? And I'm speaking in terms of the non-monetary and intangible costs that they might experience.
Honestly, I think they're both quite difficult to quantify. I think the analyses that are done do their best to look at both the perception of and actual losses incurred due to reliability events or outages of various durations.
Okay, and would you agree that more residential customers are currently working from home and homeschooling, and at this point in time with that happening more often, they may have less tolerance for outages?
That could be true. I would just note that the value of lost load that is assumed in the company's analysis based on LBNL studies is quite high. It's not that the values are, they are multiples of retail rates, right? So it's not that the values themselves are low. They're just so much lower than commercial and industrial customers.
And you're talking about purely things you can quantify, but you would agree there are some qualitative benefits that residential customers might also have from an avoided outage.
Well, many of those are attempted to be captured by LBNL studies. So they really try to get at, how do customers value, like, what is the value placed on not having those outages? So it is an attempt, it's a quantitative attempt, but it is an attempt to get at the full value of how customers value, get reliable service and the extent to which they are harmed by less reliable service.
Okay, and in your survey rebuttal testimony on pages 11 and lines 8 through 15, and I'll give you a moment to get there.
Okay.
And in that Q&A, you can see that the allocator that you have chosen for self-optimizing grid costs is different than traditional cost allocation allocators, correct?
Correct.
And you know that traditionally benefits of capacity and energy services are allocated based on contributions to peak demand, energy, or number of customers, rather than the economic benefits that you are recommending, correct?
Correct.
And this is different from the methodology that Ms. Hager described yesterday for how the company allocates all of its costs.
I assume that's the case. I didn't listen in yesterday.
Okay. So if the commission accepts your allocation method for self-optimizing grid costs, that would have the company allocating just one set of costs differently than how it allocates the rest of all of its costs, correct?
Absolutely, yes.
Okay. Thank you. I don't have any further questions.
Thank you, Ms. New. Commissioners, questions for this witness? Mr. Hall, any redirect?
Yes, briefly. Mr. Borden, can you hear me?
Yes.
Just a second, please. You were asked by Ms. New if you had visited these sites where the undergrounding occurred. Do you recall that?
Yes.
Do you believe that would be necessary for your testimony?
No.
And why not?
So it's the company's responsibility to present why its costs that it's seeking for recovery from ratepayers are just and reasonable. It's not my job or the department's to go out and seek additional information not presented by the company to determine that.
And similarly, the pages that she pointed to of the manual, it discussed that they're about other solutions and engineering judgment. Are you aware of whether the company submitted that information in its filing or testimony?
I do not believe it has, and I'd really caution the commission against approving costs based on subjective judgments of utilities. That is, I think, not appropriate.
Who, in a rate case, who ultimately has the burden to show all costs are reasonable?
The utility.
So lastly, she asked about the SOG and using economic benefits, and that I guess it would just be changing their cost of service model to change one allocation. Do you recall that?
Yes.
Is there an alternative that would accomplish the same goal that from your recommendation other than changing the allocator?
Yes, certainly the commission could disallow the residential portion of those costs. That would be another alternative, and we've discussed that in testimony.
Going to double check. I wondered, is that in your testimony?
Yeah, hang on.
I will submit that I'm not certain that it is. I know it's something that you and I have discussed, but I'm not certain. So if it is, would you point us in the commission to it? And if not, that's fine.
I need like 1 minute.
Sure. Perhaps your co-counsel is telling you page page 12.
I found it.
Thank you.
Sorry. So in my direct testimony on pages, sort of starting at line 14 on page 39, I say, while the commission could disallow all or a majority, for example, 98% of costs expected to be incurred by residential ratepayers, I recommend instead that cost allocation for these expenditures be set more equitably than the traditional allocator for a distribution plant that has been applied to SOG investment costs.
Bear with me just a second. I think I might be done. Thank you, Mr. Borden. I appreciate your time. That's all the questions I have.
Thank you.
Thank you, Mr. Hall. Mr. Borden, thank you for your testimony this afternoon. We appreciate you being with us. And you may stand down.
Great. Thank you.
Mr. Hall?
Thank you, Madam Chair. The department's next witness is Mr. Aaron Rothschild.
Good afternoon, Mr. Rothschild. Can you hear me?
Yes, good afternoon.
It's good to see you again.
Can you hear me?
Yes, sir, we can.
Yes, good. Great. Yeah, good to see you again, too. Thank you.
Mr. Rothschild, I'm going to ask you to raise your right hand and let me swear you in. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Hall?
Thank you, Mr. Rothschild. Can you hear me okay?
Yes, I can.
Okay. Could you please state your full name and business address for the record?
Yes, Aaron L. Rothschild, 15 Lake Road in Ridgefield, Connecticut.
And by whom are you employed and in what capacity?
Rothschild Financial Consulting, and I am president.
Mr. Rothschild, I'm going to just ask you early on. I don't know if you can get either maybe a little bit closer to the mic. It's not, or turn it up. It's not coming through super clear for me, at least.
Is this a little better?
It was a little better, but now your ratio on your image. There we go. maybe that was in the commission room here. Okay, let's keep going, and we'll see if it gets better. Just want to make sure you're clear to the commission. How long has your company been in existence?
Our company has, it depends how you measure it. It's been around since the late to the early 80s. Since the early 80s, yeah.
And what type of services do you provide?
We provide primarily expert witness consulting services, focusing on utility regulation issues.
And how long have you been preparing rate of return testimonies?
I've been preparing rate of return testimony since 2002, and I've testified in over 75 regulatory proceedings in over a dozen states. Before that, I performed financial analysis in the telecommunications industry in the United States and Asia Pacific.
Okay. And in this case, did you prepare 141 pages of direct testimony, which was filed on April 8th, 2024?
Yes, I did.
And did your direct testimony include 35 pages of appendices labeled Appendix A through Appendix H?
That's correct.
Did your direct testimony include 18 pages of exhibits labeled ALR1 through ALR5?
Yes.
Okay. Madam Chair, I think I've told you this before, and I'll try to remember to correct it next time. But I recognize that typically witnesses' appendices are entered as a hearing exhibit, or in this case, Mr. Rothschild's appendices A through G are essentially part of his testimony and not like typical exhibits. Appendix H is his testifying experience. So therefore, I would move to have the pre-filed direct testimony of Mr. Rothschild, including appendices A through G, entered into the record as though given orally from the stand.
Mr. Rothschild's pre-filed direct testimony, including appendices A through H, will be entered into the record. You just want G?
Through G. I
Okay.
think the way the commission has typically done it as resumes and such are typically a hearing exhibit. I don't mind including all the appendices. I just know from what I've seen with other
Appendices
witnesses.
A through G will be entered into the record as testimony, as if given from the stand.
Thank you. And I would move to have Appendix H and exhibits ALR1 through ALR5 collectively entered as the next applicable hearing exhibit.
Okay, and then a composite exhibit consisting of Appendix H, is that right?
Yes.
And exhibits ALR1 through ALR4.
5.
Excuse me. It's been a long week. ALR1 through ALR5, that will be a composite exhibit marked for identification as hearing exhibit 36 and admitted into the evidence of this case.
Thank you.
Thank you.
Sorry for being difficult.
It's okay. No, If I was a little sharper on my game on a Friday afternoon, it wouldn't be a problem.
Mr. Rothschild, did you also prepare 23 pages of surrebuttal testimony, which was filed in this docket on April 29th, 2024?
Yes, I did.
And did you also prepare 23 pages of corrected surrebuttal testimony, which was filed in this docket on May 16th, 2024?
Yes.
If I asked you, given the corrections, if I asked you the same questions today, would your answers be the same?
Yes.
Madam Chair, I would move to have the pre-filed corrected surrebuttal testimony of Mr. Rothschild entered into the record as though given orally from the stand.
The pre-file corrected surrebuttal testimony of Mr. Rothschild will be entered into the record as if given from the stand.
Mr. Rothschild, have you reviewed the settlement agreement in this case?
Yes, I have.
Do you have any concerns with it?
Well, my concern is that the 9.94% ROE is higher than the company's market-based cost of equity. And also I should note that that's in the upper end of the range of the ORS Pardue's witness cost of equity model results. And also the common equity ratio, the capital structure that contains the common equity ratio of 51.21%, I believe is excessive considering my analysis, and I believe if used could lead to overcharging consumers.
Thank you. And have you prepared a summary of your direct and surrebuttal testimonies?
Yes, I have.
Okay. Could you please read it?
Yes. My direct testimony provides my recommendation to the Public Service Commission of South Carolina regarding the appropriate cost of equity, capital structure, and overall cost of capital for Duke Energy Carolinas. The Commission should reject Mr. Coyne's recommended return on equity, or ROE, of 10.5% because it is significantly higher than DEC's market-based cost of equity, or higher than the returns investors require to provide capital to companies in the same risk category as DEC. In other words, Mr. Coyne's 10.5% ROE recommendation is not consistent with the legal standard set by the United States Supreme Court for a fair rate of return, which includes the following statement regarding the authorized ROE. The return to the equity owner should be commensurate with the returns on investment in other companies having corresponding risks. Additionally, DEC's requested regulatory capital structure consisting of 53% equity and 47% debt should not be approved for rate-setting purposes because it contains too much expensive equity. I say expensive because equity has a higher cost rate than debt, and all else equal, the more equity, the higher consumers' rates will be. On average, the regulated electric utility companies in Mr. Coyne's practice group have a common equity ratio of only 44.7%, over 800 basis points less than their 53% requested common equity ratio. And DEC's parent, Duke Energy Corporation, has a common equity ratio of only 41%. Yes, these common equity ratios of 44.7% and 41% are at the holding company level, and therefore are not completely comparable to a regulatory subsidiary like DEC. However, common equity ratios at the holding company level are irrelevant to this proceeding. These holding companies include unregulated operations that are generally riskier than those of regulated subsidiaries. Therefore, we should expect the capital structure at the holding company level to have relatively less debt or a higher common equity ratio, so they can ensure they can make interest payments as earnings fluctuate. It is unfair to DEC's customers for them to pay rates based on a capital structure with a significantly higher common equity ratio than at the holding company level of electric utility companies. In summary, I recommend the Commission authorize an ROE of up to 8.45%, a capital structure containing 50% common equity and 50% debt, and a debt cost rate of 4.56%. My ROE recommendation of up to 8.45% is the high end of my cost of equity model results, which range between 7.43% and 8.45%, with a midpoint of 7.94%, and is more than sufficient to meet regulatory standards and balance the interests of consumers and investors. A common equity ratio of 50% is on the high side of reasonable because it is above the mean, 44.7%, and the median, 43.4% common equity ratio of the 15 electric distribution companies in the proxy group used by me and Mr. Coyne. To arrive at my 8.45% ROE recommendation, I conducted a thorough technical analysis to determine the equity return investors require to provide capital to enterprises having corresponding risks to DEC. I also cross-referenced the results of my analysis with the model results of leading financial institutions so the Commission can better judge the reasonableness of my model results and 8.45% ROE recommendation. Aside from the issue with his models, Mr. Coyne's 10.5% ROE recommendation is significantly higher than the equity return expectations of major financial institutions, which range between 6.2% and 7.9% for large capitalization companies. For example, Amazon, Apple, Tesla. There is no good reason for DEC's authorized ROE to be hundreds of basis points higher than the equity return expectations for large cap, unregulated companies that operate in extremely competitive markets. If there is one, I have not seen it. In my direct testimony, I provided credit analysis that shows that if the Commission adopts my rate of return recommendation, it is unlikely that it would lead to a credit downgrade for DEC by either Moody's or S&P Global. However, even if DEC received a credit downgrade, as Mr. Bauer argues in his rebuttal testimony, the resulting increase in debt costs, 10 to 20 basis points, on the order of $3.5 to $7 million annually, would pale in comparison to the immediate savings, over $100 million annually, that DEC's South Carolina customers would realize if my recommended ROE and capital structure are used at that rate. In his rebuttal testimony, Mr. Coyne claims that my 8.45% recommended ROE for DEC is not consistent with the Hope and Bluefield standards because, one, it's below recently authorized ROEs for vertically integrated electric utilities, which range between 9.25 and 11.45%. And two, I fail to demonstrate that it is commensurate with returns on investments in enterprises having comparable risks. He claims that I rely on unconventional analytical approaches that are not reliable because, among other reasons, they produce volatile cost of equity results. Mr. Coyne's rebuttal testimony is not trustworthy because it is based on multiple contradictory evaluation criteria. For example, he attempts to discredit my CAPM by conflating bonds value and its yield. Additionally, he cherry-picks data from individual data points from individual companies to claim that my methodology, which is based on an entire proxy group, is unstable. My recommendations satisfy the requirements of Hope and Bluefield that regulated utility companies should have the opportunity to earn a return commensurate with returns on investments in other enterprises having corresponding risks. My recommendations are consistent with legal standards set by the United States Supreme Court and market data, and will allow DEC to raise capital on reasonable terms while fulfilling its obligation to provide safe and reliable service.
Thank you, Mr. Rothschild. Does that complete your summary?
Yes, it does.
Madam Chair, Mr. Rothschild is available for questioning.
Thank you, Mr. Hall. Duke Energy, Carolinas.
Thank you, Madam Chair. I'll cross the room and get set up.
That's fine.
And for the court reporter's purposes, I'm Kiran Mehta, here for Duke Energy Carolinas. Good afternoon, Mr. Rothschild. Can you hear me all right?
Yes, can you hear me?
I can. Thank you, sir.
Yes, good afternoon.
And we'll probably have a few exhibits, Mr. Rothschild, which we will distribute in the room and will display on the screen so that you can see what it is that I'm talking about. And we'll arrange for them to be emailed to you as well, so you'll have the entire document should you wish to view any of the entire documents. And Madam Chair, none of these exhibits are confidential. Mr. Rothschild, you submitted written testimony in the Duke Energy Progress, South Carolina rate case back in December 2022, did you not?
Yes, I did.
And then, as in this case, your testimony was presented on behalf of the South Carolina Department of Consumer Affairs, correct?
That's correct.
Your ROE recommendation for DEP in that case was 8.71%, correct?
That's correct.
Mr. Rothschild, I'm going to circulate to you and in the room an exhibit that captures 30-year Treasury rates, I think for the last 30-odd years. And Ms. Farmer, Ms. Athens, it's number 1 of my set.
Mr. Mehta, is the email being sent like via Wi-Fi from this room?
I believe Mr. Hall asked us to send it to him and that he would make sure it got to the witness.
My concern is that sometimes there seems to be a delay when emails are sent via Wi-Fi.
On this particular exhibit, it should be readily visible from the Elmo, so
right.
I think the witness will be able to see it. And Ms. Farmer, if you could, when you're distributing the exhibits, just make sure that Mr. Hall gets it first so that we can make sure that he's okay. And Mr. Rothschild, I don't know if you've actually gotten the entire document yet, but let me.
If you don't mind, Mr. Mehta, I'm going to forward it to him. I don't mind you answering questions about it, but to the extent he needs a second to review it while you're answering questions, if you just let me get it to him.
Perfectly fine.
Okay, I think it just came in.
Mr. Rothschild, back in December of 2022, when you filed your DEP testimony with a ROE recommendation of 8.71%, the 30-year bond yield was 3.66%, correct?
Let me just see. That sounds right, but I might just want to look at that. So what I received had a link, and if I click on that, it shows the interest rate. I should look by month. December 2022, I see 3.66%.
Chair Belser, just for purposes of identifying the document, could we go ahead and identify it as the next hearing exhibit?
I'm gonna call this Dex Cross. 30-year Treasury rates will be marked for identification as hearing exhibit 36.
Thank you, Chair Belser. Mr. Rothschild, when we say that the bond yield was 3.66% back then in December of 30-year bond yield, back then in December of 2022, what we're saying is that 3.66% was the interest rate on 30-year U.S. government bonds back in, it's probably a monthly average for December of 2022, correct?
Yes, that's right. That's the market yield. That was the average. I mean, I'm accepting your source. It's consistent with my chart 1 on page 25 in my direct testimony, which shows it's not done average monthly, but it is very similar. So to answer your question, yes, it's the market yield on the 30-year U.S. Treasury bond at that time.
Now, when you filed your direct testimony in this case, the DEC case, that was April of 2024, correct?
That's right.
And looking again in Exhibit 36, when we go to the monthly average for April of 2024, it's 4.66%, correct?
That's correct. But when I use data in my testimony up to February, which is 4.38%, but I'm fine talking about 4.66%. Fine.
Sure.
It's just a little bit lower.
Understood.
Yes.
And so again, when we say 4.66%, we say that in that month, April of 2024, at least on an average basis, investors in government bonds demanded and got 4.66% interest on those 30-year bonds, correct?
Yeah, on average for the month, yes.
And it's always dangerous to have lawyers do math, particularly in their head. But I think even I can divine that the difference between 4.66% and 3.66% is 1%, correct?
For U.S. Treasury bonds, yes.
And so the April figure is 1% higher. April of 2024 figure is 1% higher than the December of 2022 figure, correct?
You're referring to interest rates on U.S. government bonds.
Correct.
In that row. Yes.
And as I understand it, financial folks, and I'm a lawyer, not a financial folk, you speak in terms of basis points as opposed to percentages, at least some of the time, correct?
Yeah, it's usually helpful to refer to basis points in many contexts, exactly.
And 1 basis point equals 1/100th of a percent, correct? 0.01%.
That's right, 100 basis points being 1%. Yeah.
So 100 basis points is 1%, correct?
Yeah, that's right.
And so the interest rate on 30-year U.S. government bonds was 100 basis points higher in April of 2024 than it was in December of 2022, correct?
Your math sounds Right?
Mr. Rothschild, you would agree, would you not, that higher interest rates, all else equal, indicate a higher cost of equity for electric utility companies because fixed income investments become relatively more attractive when they start paying a higher rate, correct?
No, not necessarily. I mean, well, for two reasons. One, not necessarily. The relationship, I do not think, is always one-to-one in that way, but all else is not equal also. So it's important to recognize. So by my calculations, the cost of equity is not increased with these yields.
All right, Mr. Rothschild, would you turn to page 25 of your direct testimony?
Yes.
And beginning at line 8, I'll read, and you tell me if I've read it correctly. Higher inflation can impact the cost of equity because it can impact interest rates. Higher interest rates, all else equal, generally indicate a higher cost of equity for electric utility companies because fixed income investments become relatively more attractive when they start paying a higher rate. Did I read that correctly?
Yes, you did.
I understand that you think all else is not equal, not necessarily equal. I'll let Mr. Coyne deal with that. But you do agree, do you not, that all else equal, higher interest rates indicate a higher cost of equity for electric utility companies because fixed income investments become relatively more attractive when they start paying a higher rate, correct?
It's critical that all else is not equal. I have to make sure to say that. Risk premiums have come down, so it's not all else equal in this case. It's very important. And also that I think it all comes together in terms of my perspective. If you look at, let me see the page number. On page 129 of my direct testimony in Appendix E, where I show the cost of equity and how it's changed over time. And over that very time period, you can see that the cost of equity has come down. It was reaching a peak at that time in November and December 2022, and it since was at about 9.24% based on my CAPM analysis, and had come down to 7.57% by the end of November. So despite that increase in interest rates, because of the declining equity risk premium, we had a cost of equity decline.
And you would agree, I think, Mr. Rothschild, that Mr. Coyne and perhaps even Ms. Pardue might have a different take on all else being equal, correct?
Yes, my view is I feel very strongly about this, and my view is not out of the mainstream at all. If you see in the market tremendously that stock prices often are reaching highs now, continuously discussed as expensive, it's generally my view that the equity risk premiums have been coming down is far from the mainstream. And so I strongly support, based on my analysis and my review of others, that the equity risk premium has been coming down over that time period.
Just a minute. We've lost the picture on Mr. Rothschild. Is that on his end or? It's on your end, Mr. Rothschild. Can you check that? There you go.
My camera is still on. I haven't changed anything.
Wait a minute. Bear with us a second, Mr. Rothschild. There you go. You're back.
Okay, great.
Well, now you're gone. And you're back. Okay. We're having a bandwidth issue, or we're showing a bandwidth issue on your end, I think, is what my tech folks are telling me. Okay. My apologies for interrupting.
No problem, Chair Belzer. We certainly need to see the witness.
I think you had just finished your answer, had you not, Mr. Rothschild?
Yes, I believe I did. I believe there's a tremendous amount of evidence that equity risk premiums have been declining over that time period.
Okay, thank you. Go ahead.
Thank you, Chair Belzer. In any event, Mr. Rothschild, I understand that you think all things are not equal. I believe that Mr. Coyne probably has a different take on it. We'll let him have his say on that as well. But it is your testimony, is it not, that all else equal, higher interest rates mean higher cost of equity for electric utility companies?
Yes, my testimony says that, and it's all else equal, but all else is not equal. Just want to make sure.
Understood. Mr. Rothschild, let's go back again just for a moment to the DEP case in which you filed testimony, docket number 2022-254E. And I'd like to show you another exhibit. And Ms. Farmer, Ms. Athens, this is number 2 in the list, which is a copy of one of your responses to one of DEP's discovery requests in that case.
So I'm being sent an email now with this. Is that correct?
You should be.
Okay.
Chair, while this is being handed out, just wanted to, as I presume what Mr. Mehta will do, is the treasury rates, the hearing exhibit, is it 36 or 37?
Thank you. I needed to clarify that. I have it on my list as 37, but I think I read it out as 36. So the prior one, it has just been marked for identification as hearing exhibit 36. This cross exhibit, we don't have enough. This cross exhibit will be marked for identification as 38.
So did the last exhibit get entered?
It was just marked.
Just marked.
This one is just being marked.
Thank you.
Madam Chair, Scott Elliott.
Mr. Elliott?
All right.
All right, wait. Hang on a second. I can only do one thing.
Yes, ma'am.
And I got to make my notes here. All right. Mr. Elliott, yes, sir.
This might keep, but I had Mr. Rothschild's. Were all Mr. Rothschild's appendices and exhibits, all of them hearing exhibit 36?
No, sir. Appendix A through G are part of his pre-filed testimony that will appear in the transcript.
Okay.
Appendix H, along with exhibits ALR 1 through 5, I have as hearing exhibit 36.
Yes, ma'am. That corrects me.
I'm getting a nod from Mr. Mehta. Okay. Or wait a minute, that's Mr. Hall I need a nod from.
Yeah.
Sorry, I'm getting a nod from him.
I stand corrected. Thank you.
It's a unanimous nod, Chair.
Okay, now.
Very little unanimity in this case, at least on this issue, but we're okay on this one.
It takes a village to keep me straight, so thank you all very much for helping and for your patience. Okay, we will mark this for identification as number 38, and this is DCA's response to one of DEC's, well, excuse me, this is DEP's interrogatory 2.5, 2-5. Okay.
And
Marked
it's
for identification is 38.
38. Thank you. Chair Belzer, I do have just a question for you, based on, I think, what Mr. Hall just said a bit ago. Would you prefer that the exhibits get introduced into evidence, into the record as evidence as they go along, or just all at once at the end?
To keep things straight, I'd prefer as we go, but I just heard you ask that the prior one be marked. I didn't hear that you asked that it be admitted. Maybe I misunderstood.
No, you understood me perfectly well. I'd go ahead and ask for it to be admitted. So Exhibit 37 to be admitted, and while we're at it, Exhibit 38 to be admitted.
Any objection?
I mean, I guess I'd like to see with Exhibit 38, the
Okay,
second one.
37 is admitted. Let's see where we're going with 37. Excuse me, 38. 37's admitted. 38 is marked for identification.
Okay, back to you, Mr. Rothschild, and either looking at the screen, what's on the screen, or if you've received the email with the full exhibit by now, you can certainly look at that as well. But in the DEP case, DEP asked DCA a question, 2-5, please identify each rate case for an investor-owned owned regulated electric utility in which Mr. Rothschild has testified since January of 2020, correct?
Yes, I believe that is correct.
And
Yeah.
You listed these 7 matters in response to that question, along with some others. But if you keep reading down the exhibit, I think you will note that it's only these 7 for which you provided ROE testimony. And did I get that correct?
Yes, that's correct. Wait. Yes, I believe that's correct, because in California, there was a cost of capital proceeding that combined companies. That's why because it lists 10 rate of return, but it's less because of a combination, I believe. Yes, I think it should be fine for doing the comparison here.
And then the request went on, Mr. Rothschild, to ask you, this is part B, to provide the recommendations that you made with respect to ROE in each of those 7 cases, correct?
That's correct.
And this is the information that you provided in response to that question, correct?
Yes.
And the response also asked in Part B how the commissions ruled in the cases that are listed 1 through 7, correct?
Don't see that. Is that?
B, please provide Mr. Rothschild's recommended return on equity for each rate case identified in Part A and the authorized return on equity awarded in each case. Do you see that?
Yes, I do. Yeah.
And the response provides your recommendations, but declines to provide the commission decisions, essentially on the ground that those decisions are public record and DEP could find that itself, correct?
Yes.
Now, Mr. Rothschild, I'm going to go ahead and again send you another exhibit. Oh, excuse me, Chair. Could we admit Exhibit 38?
Exhibit 38 is admitted into the record.
Mr. Rothschild will send you another one. And Ms. Farmer, Ms. Athens, this is number 3 of the ones that I had prepared.
Okay, it's come in. I'm opening it now. It's open.
All right. So, Mr. Rothschild, I took up, I assume, Mr. Hall's offer to go ahead and find the commission decisions themselves and prepared this exhibit for you. The top 7 items are the cases that you identified in response to the request in what we've now marked as Exhibit 38. The middle column is your recommendation from Exhibit 38. And the third column is the ROE authorized by the commission in those cases. And Chair Belser, if we could mark this one as Exhibit 39, hearing Exhibit 39.
This document will be marked for identification as hearing Exhibit 39.
And Mr. Rothschild, I also just took a look at your Appendix H that also has, it's an updated, I guess, list of testimonies, Appendix H in this case, and added the 3 at the bottom, including the DEP case itself, which obviously you didn't have the information on at the time that you responded to the interrogatory. That is Exhibit 38.
Yes, that's right. I didn't know.
And Chair Belser, I'd like to go ahead and introduce this Exhibit 39 into evidence as well.
Madam Chair, I would just note the objection that this appears to be something made by counsel, and just there's a lot of numbers of what proclaimed to be authorized ROEs that I'm not sure we can authenticate or to determine this is the actual ROEs in those cases. I'd like to maybe understand a little bit more about where they came from, or if he has the orders, the decisions, or something other than.
Well, Mr. Hall, I'll respond to you in the same way you responded to me. The decisions are public record. You're certainly free to look at them. I'm perfectly happy to have this exhibit admitted as a preliminary matter. If you go back and check and find that we've made an error, we'll correct it.
I appreciate the commentary on our discovery responses from 2 years ago. And I think parties don't have to develop things or provide things they don't necessarily have, but we're submitting into evidence now. So I think the standard's a bit higher, and I would just ask that if they're being submitted for the truth of what the ROEs are, that we have something other than what appears to be a counsel-prepared document.
Mr. Rothschild, do you have any reason to doubt the ROEs that are listed on this exhibit? The actually authorized ROEs listed in this exhibit?
I'd just like to say I don't recall offhand. It's a little, I wouldn't be able to say for sure whether they're accurate just from my memory. That's all I can say. Not that I'm questioning your numbers, but I'm just saying that from my recollection, I would not be able to verify them from my memory.
Understood. And would you just accept them subject to your counsel and you checking them later? Which
Mr.
I'm
Mata,
perfectly
let
happy
me
to
ask
have.
this. Just let me ask this. There is a little different standard. We're not going to finish today. Can y'all bring in copies of the orders to
Of course.
to let him check to make sure that they're the same?
Of course.
All right. We'll leave it as marked for identification at this point. So do y'all getting with Mr. Hall next week, if you would.
Sure.
Thank you, sir. Okay.
But it's 39 marked for identification for purposes of where we are right now.
Yes, sir.
Okay.
It's just not admitted until we can check through it next week.
Understood. And I have some questions about it, which, we can, if we turn out to be wrong when we look at the actual orders, we'll deal with that then. We'll fix it then.
Thank you,
And again, not understanding the purpose of what you're using the stacking board. If you're submitting for these are the ROEs, and that's the purpose of it, then that's where the objection stems from.
I'm sorry. You trailed off there, Mr. Hall. If these are the ROEs, what did you say?
I'm just saying I don't know what purpose he's submitting this for yet. If he's submitting for the purpose that these are the actual ROEs, then right, we want to verify them. I'm not sure where he's going with his questions.
Okay.
So we might resolve it.
Well, I think
depending on what his
I think
questions
the
are.
document purports that these are the actual ROEs that were approved, and that is what needs to be checked, correct?
That is correct.
Thank you.
Mr. Rothschild, again, assuming that we did our review of those orders correctly, and the authorized ROEs are as they appear in the third column, is it fair to say that the commissions that decided these cases came to an authorized ROE that was considerably higher than your recommendation?
Yeah, so you can just see the math. I mean, my role as an expert witness is to provide an analysis that shows what the market-based cost of equity is for utility companies, and it's I'm not a commissioner. It's not up to me to decide.
And is it also fair to say, Mr. Rothschild, that when you look at the second column, that you generally provided a range of ROE estimates in addition to a point ROE estimate, correct?
That's right.
And is it also fair to say that as a general matter, the ROE point estimate that you recommended to whichever commission it was towards the middle of your range, correct?
You know, it's almost always at the midpoint. That's correct.
But it was not in this case, correct? Your ROE point recommendation is the very top of your range, correct?
That's right. That's yeah. Like it's rare that I do that. In this case, I did.
The midpoint of your range in this case would have been 7.94%, correct?
That's right.
Mr. Rothschild, were even you embarrassed to make a point recommendation of DEC's ROE in the sevens?
No, not at all. I mean, if you see the equity return expectations of major financial institutions, I mean, how hundreds of billions or even trillions of dollars is managed, that would certainly be more in line with that, how money is managed around the country. I certainly would not be embarrassed, and I think if the commission would take my full range seriously, I would be supportive as low as 7.43%. I believe this is what capital markets are saying.
Nevertheless, in this case, you actually picked as your point estimate the highest point in the range, correct?
I did emphasize that, and I see the exact wording, but I believe what I was explaining was that would be the highest, that would be consistent with the capital market data that I could support. I think there's been a lot of debate over time about what the range actually means, and this is not something that we can measure precisely, the cost of equity, like we can in, say, physics or something. So that's why I give a range. And I did in this case just to emphasize that the 845 was still within that range. But I think the commission, I hope, would consider the full range, including that midpoint at 794 and even to the lower end of my range of 743.
Mr. Rothschild, you testified, I think you said in your summary, and you certainly testified in your written pre-filed testimony, that your recommendations, both with respect to ROE and the company's cap structure, will allow the company to raise the capital it needs to provide service to its South Carolina customers. Did I get that basically right?
Yeah, that's in the interest of consumers. Of course, consumers would not benefit from an authorized ROE or capital structure that would not allow the company to raise money.
But your recommendations, in your view, would allow the company to raise the capital it needs, correct?
Yes.
Mr. Rothschild, I'm going to send you another exhibit and have it passed around, and this would be number 6 in the set. Mr. Rothschild, do you have the emailed exhibit?
I'm looking, it hasn't come in yet. Hopefully it will momentarily.
Just let me know when you've gotten it.
Okay, all right, so coming in. Is this enough for me to see, to be able to ask questions, or should I wait and see the whole?
Oh, no. I have questions for you. I just want to be sure you have the document.
Okay.
So just tell me when you have the document.
Okay, I will.
We're going to go on to the rest of it.
Okay, it's come in. Let me open it.
And Chair Belzer, while we're waiting on that, if I could have this marked with the next hearing exhibit number, which would be
This
39.
document will be marked for identification as, I've got 40.
Oh, 40, you're right.
Sorry.
I have the document open now.
Okay, thank you, Mr. Rothschild. And what I have on the screen, what the document is a copy of what's called Act 220 in South Carolina that was enacted by the General Assembly of South Carolina in 2022. And it does a lot of things, but what I want to focus on is the highlighted part of the preamble, which indicates that one of the purposes of the Act is to express findings of the General Assembly regarding the importance of economic development and the role that electricity and renewable energy play in it. Did I read that correctly?
Yes, the highlighted part, that's correct.
And in fact, when you flip down to page 4 of the exhibit, Mr. Rothschild, in support of this legislation, the General Assembly specifically found that, quote, the economic and financial well-being of South Carolina and its citizens depends upon continued economic development and opportunities for employment, didn't it?
That's what I see, yeah.
You would agree that that would be a very good thing for the state of South Carolina and its people, correct?
Yeah, I would think so, certainly.
And the General Assembly made a further legislative finding that indicates that renewable energy sources for electricity are important factors that decision makers of potential investment opportunities take into account when making a decision to relocate or expand within the state, correct?
Yeah, I mean, I haven't reviewed the whole document, but I'm sure there is an issue about the cost of renewable energy as well. And that's something that was a passion of mine for many number of years, and I worked on it in California because when renewable energy was being promoted there was a lot of kind of arm's length deals that were going on between, they were dealing with large kind of utility scale investments, and what I had thought about was a way to California to get the renewables they wanted, but as cheaply as possible. And what I had decided was the best to do was to come up with a type of auction that would allow the market to decide. And someone got ahead of me on that, and there was a renewable auction mechanism that was implemented in California that significantly reduced the cost of renewables by having a market mechanism. So I just want to mention that because I haven't seen this whole document, but my passion has been making sure if there's going to be renewable energy that it's done as cost effectively as possible. And the program that I hope everyone would kind of review would be the renewable auction mechanism in California, which is extremely effective using what we call the reverse auction.
Thanks, Mr. Rothschild, and we'll we'll leave that one to the General Assembly too, perhaps. But
I think they should review it.
I guess just to try to summarize it without belaboring each one of these findings, the General Assembly was highlighting in this legislation the need for utilities in this state to be able to make investments in energy sources, including renewable energy sources, in order to attract commercial and industrial investment into the state, correct?
Yes, I can see that.
And so the General Assembly was encouraging the utilities in this state to encourage investment in this state so as to accomplish the state's economic development goals, was it not?
Yes.
And again, attraction of additional investment in the state, to the state, would be a very good thing for the people of this state, correct?
Yes, it would, and that's why I carefully analyzed what the required return are for investors. So I believe if my recommendations were authorized, it would allow this this legislation to be carried out, and also it's critical. I assume it's in this document that the businesses and consumers in the state do not overpay for electricity. That would also be extremely important for the economy.
Well, we'll let the document speak to itself as to what its other provisions are, Mr. Rothschild, and move on to another exhibit, which is number 7. And Chair Belzer, while that is being circulated, I'd like to go ahead and just move the admission of hearing exhibit 40.
Hearing no objection, hearing exhibit 40 is admitted into the evidence, this case.
Okay, it's coming. I'm going to download it now.
And Chair Belzer, I'd like to have this document marked as Exhibit 41 for identification. It's a copy of an article from the state newspaper.
This article from December 22nd, 2023 will be marked for identification as hearing exhibit 41.
And Mr. Rothschild, just looking at this article together, I mean, the headline basically says what's in the article. South Carolina is the fastest growing state in 2023, according to new census data. Do you see that?
Yes.
And we can certainly look at the census data if you would like, the underlying census data, but you have no reason to doubt the reporting by the state newspaper in this regard, do you?
I do not have any reason to doubt. I would accept subject to check, but I have no reason to doubt it.
If we can take a look at number 9 in the package, Ms. Farmer and Ms. Athens. Chair Belzer, I'll go ahead and move the admission of Exhibit 41.
Madam Chair, I'm going to object to this one. I don't see what the relevance of a state article is, and we've had one statement that council asked him to read the headline of it. I don't see the relevance of a state article about South Carolina being the fastest growing state to Mr. Rothschild's determination of a market-based cost of equity in this matter.
Chair Belzer? Mr. Rothschild testified that his recommendation is sufficient for the company to raise the capital it needs. I'm certainly entitled to explore that assertion by Mr. Rothschild, and these documents, along with a few others that we'll be showing him, do exactly that.
Are you going to have questions? I mean, are there further questions about this article?
All I'm asking is, or all I asked Ms. Rothschild is, does the state article, and we can certainly look at the underlying data if he wishes, indicate that South Carolina was the fastest growing state in the nation in 2023.
Okay.
And that is, in fact, stated in the article.
And I guess I'll add another objection. I'm not sure if this is the best evidence to the state article about, I believe a study is referenced. Not sure if the study maybe would have been better, I believe. I guess I'm still not seeing the relevance in order to admit this at this time. If he wants to keep developing his questions, I guess we'll be happy to listen.
A study, or I think it says the census data, isn't it?
What I read on the second page is South Carolina has been a popular place to move in 2023, ranking as the fastest growing state for the year, new U.S. Census data shows. We have the census data. If Mr. Hall would like for me to mark it and introduce it, we can certainly do that.
I'm not sure I still understand the relevance, Madam Chair, so my initial objection.
I can kind of see where I think where he's going, but
I have no problem if he wants to keep going and admit them. I know you requested that he maybe enter them one at a time if we see if there is some relevance to it, but at this point, the state article to me is not relevant.
well, I think he's trying to make his point, but I think you need to make it a little clearer. Are you going to have further questions about this?
No, I think we covered what the article said just now in the colloquy with Mr. Hall. I do have the census data. We're certainly happy to put the census data into evidence if Mr. Hall would like, but the census data doesn't say anything different from what the article says.
Still not sure what it has to do with Duke being able to raise money with Mr. Rothschild's ROE, but maybe we'll get there.
You have the census data? Is that more reliable?
Sure.
Well,
It's number 8 in the package.
I think the question is tying it together, Mr. Mehta. I think I see where you're going, but Mr. Hall is asking for it to be tied a little more.
Okay.
Tied up a little more.
And I think that the tie will become very clear in probably just a few minutes.
Thank you, sir. Well, we'll revisit admitting it at that time.
That would be great.
Thank you, sir. I appreciate your patience with me.
I guess I'm being sent another exhibit, is that correct?
That is correct. And Chair,
Actually, if I can just, I understand if you don't want to, but do you have any hearing exhibits you have? If it would speed things up, I'd be happy to send a batch email to Mr. Rothschild. Understand if you wouldn't want to do that, but if there's any way to make it more efficient, we'd be happy to oblige. That's all I'm saying.
I think there's only one more, so I think we're getting close, Mr. Hall.
Okay, I have this one, I just opened it.
And Mr. Rothschild, this is a release from the Census Bureau dated December 19th, 2023, U.S. population trends return to pre-pandemic norms as more states gain population. Do you see that?
Yes, I see that title. Yep.
And Chair Belzer, I'd like let's go ahead and mark this one for identification as Exhibit 42.
42.
And I think the last page of the exhibit, Mr. Rothschild, in the circled table has the census data regarding percent population growth with South Carolina at the top of the heap, correct?
Yes, I see that.
Mr. Hall, I misspoke. There are two more exhibits. We'll go ahead and just distribute them both at the same time, just to save time. And so, Ms. Farmer and Ms. Athens, if you could get. I think I messed up my numbering system.
Okay.
Oh, yeah, number 9 and number 11.
Yeah, I'm opening number 9. I have it open.
I think it's being distributed in the hearing room, so we'll wait for just a second. The email was faster than the distribution. 9. Chair Belser, the document that's from the South Carolina Department of Commerce called 2023 Recruitment Overview, I would ask to be marked for identification as Exhibit 43. And the document that is the Governor's Executive Order 2023-18, I would ask to be marked for identification as a hearing Exhibit 44.
South Carolina Department of Commerce recruitment will be marked for identification as 43. South Carolina Executive Department Office of the Governor Executive Order number 2023-18 will be marked for identification as hearing Exhibit 44.
And Mr. Rothschild, if you would, looking at the Department of Commerce 2023 statistics, they reflect, do they not, that in 2023, the department indicated $9 billion of capital investment, second highest in the state history, and leading to creation of 14,000 jobs. That's what their release says, correct?
Yes, I mean, obviously I haven't seen these documents before. I'm just agreeing that this is what these documents say. Yes.
Understood. And then finally, Mr. Rothschild, the document that we've marked for identification as Exhibit 44, which is the executive order from the governor. Notes in the third whereas clause. Statistics regarding investment in 2022. Noting capital investment in excess of $10 billion, largest in the state's history, correct?
Good. I agree it says that, but I just have to say, once again, I haven't reviewed the document, so I don't know if it explains why this is the case and so forth.
Understood. And would you also agree Mr. Rothschild, that in the second, third, fourth whereas clauses, Governor McMaster again recounts findings that the state of South Carolina has in recent years achieved and is continuing to achieve success in economic development, bringing growth to the state and jobs and prosperity to its citizens. And again, I'm paraphrasing, but just let me know if I've misspoken.
Yeah, I would agree.
So, Mr. Rothschild, let me try to wrap up here. Sorry, I have too many papers flying around, but I think we'll get to it. So just to recap, Mr. Rothschild, from the census data that we looked at, South Carolina has the fastest rate of population growth in the nation. It's right at the top of the page that I am showing on the screen. And that in 2022 and 2023, when you combine the Department of Commerce data with Governor McMaster's data, about $20 billion in investments, bringing in thousands of jobs. And then, Mr. Rothschild, if you look at the executive order, and specifically at the first whereas clause in the order, the governor states, whereas the state of South Carolina has significant interest in ensuring the safety, security, efficiency, affordability, reliability, resiliency, and sustainability of the state's energy resources, and then the highlighted part that is on the screen, as well as enhancing and diversifying South Carolina's power production capacity, the sufficiency of which is critical to protecting the public welfare, maintaining and advancing economic development and job growth, and fueling the state's current and future prosperity. And then reading again from the fifth of the whereas clauses in the executive order, the governor's executive order. Although South Carolina is uniquely positioned to attract additional investment and to foster further innovation and economic development, the state also must not take for granted the essential role of and critical need for sufficient power supplies and electric generation resources to secure the current and future prosperity of all South Carolinians. Did I read that right?
Yeah.
Did you consider any of the factors that are on the screen? Fastest rate of population growth in the nation, the billions of dollars of additional investment bringing in thousands of jobs, the need of enhancing and diversifying South Carolina's power production capacity, which is critical, according to the governor, for the purposes outlined, and that the state must not take for granted the essential role of and critical need for sufficient power supplies and electric generation resources to secure the prosperity of which the governor spoke. Did you consider any of these factors in deriving your ROE recommendation of 8.45% in this case?
In general, yes, because as I stated in my direct testimony, it's in the best interest of the company's consumers for it to be able to raise capital, and this is certainly related. If DEC's authorized ROE is too low, it's not good for its consumers or the state. So I provide expert testimony on what's the market-based cost of equity, market-based cost of capital overall that would allow the company to raise the capital to do its need. If it's above the market-based cost of capital, it's harmful to its consumers and the state's economy. You read my testimony that my area of expertise is looking at the market-based cost of capital, and that's critical for both the interest of consumers and the utility companies' investors.
So it's your testimony, Mr. Rothschild, that you did consider these factors: the high growth rate in the state, the capital investment that has brought thousands of people and jobs into the state, the need to diversify and enhance South Carolina's power production capacity, and the critical need not to take for granted the essential role of sufficient power supplies and electric generation resources to serve the people of this state in your 8.45% ROE recommendation?
It's clear from my testimony I did not do a specific economic analysis of this state and these issues. I mentioned it's the first time I've seen the reports that you showed me directly, but I just want to make sure that it's clear that I believe the 8.45% ROE, the market data shows that that's the return that investors demand, and they will provide capital if they can expect that return. That is my testimony.
You would agree, Mr. Rothschild, that the market for equity capital is a competitive market, would you not?
Absolutely.
And you agree that DEC competes for capital in that competitive market?
Yes.
And investors participating in that competitive market have choices on where to deploy their capital, don't they?
Yeah, that's a fundamental principle of all my models. I look to the prices that investors are paying, and I measure the cost of equity based on that intense competition that between investors to access stocks and stock options.
So I guess another way of saying that, Mr. Rothschild, is investors vote with their wallets, do they not?
Absolutely.
Mr. Rothschild, do you have available to you Mr. Bauer's rebuttal testimony?
Yes, I do. One moment. Yes, I have that in front of me.
Madam Chair, I just wanted to ask working under the assumption here that this is going to be entered into the record?
Which?
Mr. Bauer's rebuttal? I'm not
Well, I
sure
guess
that,
it will be eventually.
okay.
Come next week.
That's
I think you'll be here.
just asking because as far as I know, it has not been entered. And I'm fine with the questions as long as
As, lo-
it's going to be entered as
Is-
pre-filed.
as long as it's tied up while entering it in next week. Okay.
Just making sure.
Thank you.
I thank you. That's a very valid point. I appreciate it. Mr. Rothschild, I'm looking specifically at Mr. Bauer's rebuttal, page 25, table 2, which is a chart that Mr. Bauer put together. I'm sure you're very familiar with it. And you note, just as a for instance, that Georgia Power in 2022 received a authorized ROE of 10.5%, correct?
Yeah.
And Mr. Coyne, I don't know if you heard Mr. Coyne's testimony yesterday, but he indicated that the equity ratio for Georgia Power in the same rate case was on the order of 56%. Does that ring a bell for you?
I don't recall. He said that the authorized ROE for Georgia Power had a common equity ratio of 56%.
Yes.
I'll agree to that subject to Tariff.
Okay. Mr. Rothschild, an investor facing a choice between investing in the Southern Company, the parent of Georgia Power having an ROE of 10.5%, and a utility whose ROE is pegged at 8.45%, would, all else being equal, opt for the higher return. Isn't that correct?
Investors cannot earn these returns. You talked about a competitive market. Investors have to buy at the market price. They cannot buy at book value. These authorized ROEs are applied to rate base, which is nearly identical to book value. If you go to your E-Trade account or they're no longer there, Charles Schwab, and want to buy the stock, you have to pay at a multiple of book. So the investors cannot earn at this return. As a matter of fact, what my models are saying is these authorized returns, when you compare it to the prices that they're paying in the market, mean that investors are demanding an 8.45% return.
So I guess the Georgia Power folks are really overpaying, in your view?
I believe that they're overpaying, and I want to. This is not my opinion alone. I have to read something directly from my direct testimony on this, and this is from Alfred Kahn, who's a prominent person who's written a lot about regulation, and he talks about this very topic. And I just want to read it because it's very important. What you're bringing up is often done. We're looking at authorized ROEs. These are applied. These are accounting returns. They're applied to book values. Compare this to my market-based recommendation of 8.45 is incorrect. And this is on page 17 of my direct testimony, starting on line 1. In his 1970 book, The Economics of Regulation, Principles and Institutions, regulatory economist Alfred Kahn explained why the cost of equity is lower than authorized returns when market to book ratios are significantly above 1. And you can see in the market to book ratios now of electric utility companies are about 1.5. And what he says is the sharp appreciation in the prices of public utility stocks to 1.5 and then 2 times their book value during this period reflected a growing recognition that the companies in question were in fact being permitted to earn considerably more than their cost of capital. The source of the discrepancy between market and book value has been that commissions have been allowing R's, return on equity, in excess of K, market cost of equity. If instead they set R equal to K, or proceeded at some point to do so, the discrepancy between market and book value would have disappeared or would never have arisen. It's very critical. I feel like as my role here as a witness is to explain why what we're trying to do is get the market-based cost of equity here, and you're showing here these accounting returns, these authorized return on equity from the past.
Mr. Rothschild, is it your opinion that an ROE analysis is an academic exercise?
I don't know what you mean by academic.
Well, you quoted Alfred Kahn, who's a very prominent academic. Is what you're doing an academic exercise?
I wouldn't characterize it that way. I'm doing an analysis based on market data. This isn't for an academic journal. This is for my analysis having very real consequences in terms of prices the consumer is going to pay, and also the capacity of DEC to raise capital. So I don't like to refer to it as academic in that sense. It is logical, it is analytical, so it has some overlap with what might be called academic, but I think it's distinguished in the sense that it's for very practical purposes here, very important practical purposes.
And the practical purposes are, I think, as you just stated, what customers have to pay and the company's ability to attract equity capital and debt capital, for that matter, in competitive markets, correct?
Absolutely.
Chair Belzer, I don't have anything further of this witness. It's also 10 minutes to 4. If you would like, I can wait until next week to go ahead and complete the introduction of these exhibits.
Let's see where we are. I have outstanding, let's see, 39 we're going to hold on till you bring in the orders or confirm those numbers with Mr. Hall on the ROEs from other states. Okay. We've got our article from the newspaper, the state, from December 22nd. Is there still an objection to that, given the release from the U.S. Census?
No objection.
How about the U.S. Census?
No objection.
And the recruitment overview, Department of Commerce?
No objection.
Governor McMaster's executive order?
No objection.
Okay. The exhibits 40, 41, 42, 43, 44 will be admitted into the record. We will see if number 39 is tied up next week.
Thank you, Chair Belzer.
Thank you. Commissioners, questions for the I'm sorry, Mr. Mehta, you're through?
Yes.
Okay. Questions from commissioners? Commissioner Caston?
Thank you, Madam Chair, and I'll ask these quickly if you can answer them quickly. Can you hear me, Mr. Coyne, Mr. Rothschild?
Yes, I can.
All right, thank you. Speaking of Mr. Coyne, in his pre-filed testimony on page 6, lines 2 through 5, he stated strict adherence to any single approach or the specific results of any single approach can lead to flawed conclusions. Do you agree with that statement?
Well, that's a good question. I don't think we should blindly rely on any one single method. So I would agree with that. I don't think we necessarily get there by adding more and more methods. If you add more and more methods that are flawed, you're not going to get any closer to the answer. So it's critical. I would rather have one good model than 1,000 bad ones. Make it important. But given, again, like I said earlier, capital markets are not like physics. We can't be really precise. They're constantly changing. So I like to consider it from many different angles and have tests that can make sure that the models are really on track. So I hope that answers your question.
Well, I think so. In general, what I think I heard is generally, yes, you would generally agree with that statement that strict adherence to any single approach or to the specific results of any single approach can lead to flawed conclusions.
Yes, I think so. I think that's what's got us in trouble in the financial crisis. We thought models were almost more accurate than they were. We had too much faith in them. So yes, I agree. We can't just blindly, mechanically accept models. Yes.
All right, thank you. And on page 8, lines 16 through 18 of your direct testimony, you state, to arrive at my recommendation, I applied the constant growth and non-constant growth versions of the DCF and 8 variations of the CAPM methodologies to a proxy group of 15 publicly traded electric utility companies. Is this correct?
Yes.
Is it unusual or is it recommended to use only one model when determining and recommending ROE ranges?
Well, again, I just repeat, I'd rather have one good model that we're kind of checking than a bunch. But yes, I mean, generally speaking, I see in proceedings people using more than one model, as I have done. I personally would want to see things from different angles and not just use one model. Yes.
Okay. Relative to access to capital, would or could an ROE that is appreciably less, say, than the average in the region or in the industry, negatively impact DEC's ability to attract or access capital?
Well, it's really critical. My role is to provide my expert opinion on what the market-based cost of equity is based on capital markets. And in general, that's what represents the core principles in my understanding of regulation as a substitute for competition, is to make sure that the authorized ROEs are consistent with our analysis of competitive markets, where we see what investors are speaking with their wallets. So that's what I believe, that if authorized ROEs are set consistent with the market-based cost of equity, it would not put a utility company at a disadvantage, and it would best balance the interests of consumers and investors.
I understand that, and believe it or not, I think I understood what Alfred Kahn said. All of those things said, and again, I'm not trying to trick you or force you into any answer you don't feel comfortable with. I'm just trying to get a relative sense of reasonableness. And if all things equal, utilities in the region, whether they're artificially high or not, these approved ROEs, all things equal relative to the region or the industry, if DEC's ROE, whether it's artificially high, if it is lower, or let's say appreciably lower than maybe the other utilities in the region or industry that maybe have unduly high or artificially high ROEs, if just as an example, could it negatively impact, or could it impact DEC's ability to access capital markets in competition with the others?
Yeah, it's certainly a good line of questions, and it's my first answer is no, because like I said, investors speak with their in the markets, and we can see what returns they're requiring. And if an authorized ROE is 8.45 for one utility, and there's another utility that has an authorized return of 10.5%. Like I had said earlier, investors cannot earn that 10.5%. to get access to that, they have to pay a premium in the market. Right? So in a pure sense, when you compare those two, that authorized ROE of 10.5%, investors are earning, I believe, about 8% or so. So my first reaction is no, but it's important that we. I guess I'm struggling a little bit because that's why sometimes I do recommend sometimes at the top of my range, because I can understand the position that commissioners are in terms of trying to consider many different factors. But I would say that in general, it's much better if we move towards, even if it takes some time, we move towards authorized ROEs that are in line with the market-based cost of equity. I believe that's in the best interest of the economy of the state, of the consumers, in a broad sense. And I believe authorized ROEs are too high. In terms of how commissioners get there, that has to be done in based on their judgment.
I think I understand that. Thank you. Final question. If lower ROEs could affect DEC's access to capital, does this or should this outweigh the potential savings to ratepayer and customers? Again, all things equal. And look, I'm not saying there's one right answer, but it seems like a reasonable question.
It's very reasonable, certainly. I mean, these are critical services, and you want to make sure they have access to the capital, and I understand why you would be very potentially cautious about that. And I hear that argument often. We say, this is such important service, maybe error on the high side and go above the market-based cost of equity. I just want to emphasize, I think that consumers have been overpaying for a considerable amount of time, and I think it's better that we move towards what that market-based cost of equity is. And I think that isn't the best. That is really, I think, balances the interest best of consumers and investors. And so I mean that's my testimony. And in terms of how a commission decides the risk trade-offs and various tests, I could understand, but I think we really should consider moving towards a market-based cost of equity so consumers are not overpaying.
Okay, thank you. Thank you, Mr. Rothschild. And I notice through your windows the weather looks nice in Connecticut. I hope it is.
Thank you. It is. Appreciate it.
Thank you very much.
Thank you.
Mr. Hall, we needed to stop at 4. And I hate to do this, but is Mr. Rothschild available on Tuesday afternoon at 2 o'clock?
I had not had a chance to ask about Tuesday afternoon at 2. I believe he.
I'm sorry, Wednesday.
Wednesday afternoon at 2. I believe he is. Is it okay if we just?
I think we need to finish with that because if I go much longer, we're going to lose a commissioner from being able to consider this docket. So the statute allows the chair to stop the hearing if somebody's going to be out more than 15 minutes, and I don't know how long we're going to go, and I hate to do this, but I did say that we would end at 4.
Understand.
Ladies and gentlemen, I do apologize, but I can't afford to lose a commissioner when we're already down 1. So we will resume and Mr. Rothschild, I'm sorry to not allow you to finish today, but we need to end it today, and I hope that you can. We will accommodate him as we can on Wednesday to finish up with any questions. I appreciate your understanding.
Thank you.
Thank you. Ladies and gentlemen, I wish you all a good weekend. I appreciate your patience and diligence in pushing through the last couple of days, and we will be back at 2 p.m. on next Wednesday, and I'm not even going to attempt the date, but Wednesday of next week. So thank you all very much. We're in recess until Wednesday at 2 p.m. Thank you.